Hello, my name is Brian. I own and operate Clear Skies Properties, and we're a small company that buys and sells vacant land. And such, it seemed like a good idea to put together some tutorials and little primers, kind of at a beginning entry level for people who are interested in buying land and maybe have some questions about how to proceed with some of the questions that you're going to have to be able to figure out so that you do your due diligence, your homework, so that you know what you're getting into. This tutorial is going to be on the subject of easements. The whole question of boundaries, being able to figure out where your boundaries are for your property. It's not always so easy if you're buying remote land. Also, the question of access, being able to get on and off your property, being able to establish your easement, as it's called. Egress and ingress to your property, and also to determine whether or not there is egress or ingress existing on your property, on your own property, that other people will be entitled to use to traverse your property. So those are important things to know that aren't necessarily common knowledge. I used a couple terms just now that I'll go ahead and define. Easement is an easement is when there's a portion of someone's private property that is available to use for certain purposes by certain specified other people. For example, a utility easement means that there's a section of your property that a utility company can use as they need to. I have an easement on the back of my property. It's access for the utility company to get back and service the power lines and such. So I can't actually develop that part of land, but I'm also responsible for maintaining it. I went for years without knowing that that was actually mine until I got a little slip from the fire department saying I needed to clean up some weeds, and I said I didn't know that was my job. I should have known that, but I didn't. So it's not necessarily obvious that there is an easement on your property. And a lot of people have easements on their properties and they don't know about it. And sometimes when they find out about it, they're pretty upset, but such is life. Easement is designated as for the purposes of egress and ingress. Egress is getting onto your property, getting egress with an E is getting off, with an I is getting on to the property. You need to be able to get onto your property, otherwise there's very little point in having it. This brings up the question of whether or not your property is landlocked. And that's kind of a serious issue. You might buy a piece of land and find out later that it's landlocked, meaning that there's no way for you to get onto your property. There may be a road there, there may be a way of driving onto it. In other words, there's physical egress, there's physical means for you to get on there, but it's not legal. You have to have physical and legal egress and ingress onto your property. No point in having one without the other. You need to have both. So how do you determine that? It's I should say right off, I work in California principally. So in California is a state where technically by the law you cannot deny someone the right to get onto their property. So in California there are no landlocked properties. But there are properties in California where how your egress and ingress is determined is still a matter of question. You may have a legal right to get onto your property through the southern neighbor, but maybe that southern neighbor doesn't recognize that, and you have a little dispute that you'll have to settle. So sometimes these disputes can become involved and involve court cases, and it can become expensive and involve the cost of a lawyer. Hard feelings, things of that sort, troublesome neighbors. But in California, at least, there is always a way of determining, of getting onto your property. Now, that's not true in all states. And there are states where you might really get stuck where there is no way of getting on and off your property. And I'm not, it's beyond the scope of this tutorial to list where your state is on that scale. So how can you find out if there is an easement on your property? If there's a utility easement, you could actually just call the utility companies and ask them, and they'll be able to tell you whether or not they have the right to drive onto your property. If there is a easement for public access, meaning for neighbors to be able to get onto their property, that is a more involved question. It's something that will be recorded in a deed. It must be recorded in a deed. If it's not recorded in a deed, then it doesn't exist. That means that someone, at some point when they bought that property, would have had to have put it into the legal description of the deed, language that determines where those easements are. It'll say something like reserving on the, and I'll show you in a little bit on some deeds, reserving on the west 30 feet of the parcel public access for neighbors to get onto their property, something to that effect. Problem is, that language tends to get dropped off of subsequent deeds. So for example, somebody in 1950 owns a big chunk of land in the middle of nowhere, and he subdivides it. And when he subdivides it, he's going to make all these different parcels, and he's going to make sure that every parcel has an easement to get on and off that property, somewhere between the established county roads or state roads and your actual property. And that's going to be traversing somebody's private property. You're going to have to traverse other people's lots to get onto that property. And they're going to make sure that every property has that, because he's not going to be able to sell it for very much at all if there's no way to get onto the property. So when he drew that up back in the day, he would have made sure that that language was in all the deeds, that there is this easement for public access. Problem is, as these properties get sold and resold, for reasons that I'll never understand, that language just gets dropped. It shouldn't. It's just crazy that it does, but it does get just dropped. So on a contemporary deed, it may have no language at all about an easement traversing through your property or through your neighbor's property that you'll need to use to get onto your property. Crazy, but it's just the way it is. So what you have to do then is you have to do a survey or an easement search, similar to a chain of title search that I talked about. And I talked about this in another tutorial. But basically you need to go to the county recorder's office and go to the records department and do a search through the computer records and look up the current deed and then the deed before that and the deed before that one. And you have to just do a chain of title search until you get back to the deed where they still contain that language. And you may need to do that for every parcel that you need to traverse to get onto your property. And you may not know ahead of time, well, which one of these properties do I have to drive through to get onto my property? Do I come from the east or the south? How do I get on here? Well, you have to look them all up until you find it. What you do is you go back, you just look back until you get to what I call the mother lode, that point back in 1950 or whatever, when someone did all the big subdividing. They would have made sure that that language was in those deeds. It just gets dropped on subsequent deeds. So once you get back to that mother lode, 1958, when Joe Johnson sold all these properties, he would have made sure that every deed in that area at that time had that language. And once you can just go back to that period, find that person's name, and then you can look up all the relevant deeds and all the neighbors' properties until you find all the easements in that area. Yeah, it's a lot of work. But it's free is the good news, and it takes about a day, maybe some frustration, and you may have some trouble figuring it all out. Sometimes it can get very confusing doing a chain of title search. The good news is that you can pay people to do this also. Chain of title search is probably not going to cost less than $400 at where I'm at, but it'll typically be a title company. If you could look at a title company and just ask, do they have somebody there that can do survey, that can do easement surveys? And there's also some online companies that will do that. Pro Title USA is one. There's others. Their names are escaping me right now, but you could just do a Google for companies where you can do online searches for deeds or online searches for easement search. You can use terms like that. And there will be some companies that for a fee will do that research for you. But even when you have that, the truth is sometimes you may have a neighbor that says, well, I don't care, I don't believe it. You may still have a little bit of a fight on your hand. It's unfortunately, that's just the way people can be. People don't like discovering that there's actually on the west side of their properties, you can drive across it. And they didn't know that. And they've had this property in their family for 30 years, and we didn't know about that. And when you tell them that, they don't always take kindly to it. But, you know, that's just the way the cookie crumbles. Another alternative, if you can't find this, or for some reason if the easement that you find isn't satisfactory to you, you can always buy an easement from, you know, if you say, for example, you have legal access from the east, but when you get there and you look at it, boy, the physical access is crummy. It's really rugged. It would be so much nicer if you could come in from the south, but you don't have legal access there. Well, you can contact that neighbor and make an offer. Can I buy access through, you know, the west 15 feet on your property, and you can write up a grant of it's a deed determining easement, and you would have to have it recorded with the county. And you know, if they'll do it for free, then great. If they want some money for it, then that's just what you may need to do. But those are your options. Again, if you're in another state, you may need to do that. You may have to establish that somewhere. There are some other ways of securing easement onto your property. I'll go into them a little bit later. Quite often you'll find in some deeds where it'll say subject to something like subject to all easements of record. And that's their idea of including it in the deed. Subject to all easements of record. And it's like, well, what does that mean? What are the easements of record? It's better than nothing to see that, but it's not terribly helpful. You need to actually have the language specifying what those easements are. If you go down to the county records department and just ask them directly, can you help me figure out where the easement is onto my property, they're not likely to be very helpful, because that sort of constitutes legal advice. In many counties, at least, they're prohibited from. In California, they're absolutely prohibited from offering anything that resembles legal advice. So they're not going to help you at all. You're going to have to get down and do that work, looking through the records. Again, it's free, but it's still a bit of a bother. I'll just give a real quick thumbnail of the process of doing your own records research. Like I said, I did a much more in-depth one elsewhere. But typically what you'll need to have some identifying information for your parcel, the name in particular of the person who's on. If you're interested in buying a particular parcel and you know you're looking at buying it from Joe Johnson, then you would go down to the counties and look up by name Joe Johnson, and that'll bring up all the properties that he owns. And then you'll need to figure out which one of those is the one that you're looking at. And the way you can do that is by opening up each one on their computers and matching the legal description. So you have to have a current deed in order to be able to do that, that tells you what exactly the legal description is. And you find that, and then you just go back in time. If Joe Johnson bought that property from Jane Joe, then you're going to look up, do a document search for Jane Joe, and that'll bring up all of her documents, and you'll need to figure out which one is the one where Jane Joe sold to Joe Johnson. And you just work your way back in time, with each instance looking up the legal description, looking for your the language that you need to establish easement. And the thing is, you may need to go back to the 50s, not uncommonly, or earlier. You may have to go back before the computer information is even available in the computer database. Usually, with most counties prior to the 1950s, it's not on the computer database. It's on microfiche, or you have to use the older system of looking up on the little microfile things. So, but you just work your way back in time until you find that. the deed that you need. If you're buying a property from myself, from Clear Skies, I'll be happy to provide you with the deeds that I've got. And I always do this before I buy properties. So I don't buy properties that are landlocked almost without exception, or where there's going to be access issues, because it doesn't work for me. So I'll have established to my satisfaction that there's access, but you might want to do this yourself. Maybe you think I may have forgotten something or missed something. So, or if you're buying property from somebody else, you'll need to do this kind of on your own. I would give you a copy of the current deed if you were buying it from me. But if you're doing this separately on your own, you'll need to get the current copy of the deed, typically off of the county website. They'll have a service like Parcel Quest or some other service, not always, but they will quite often have an online service where you can at least look up the current deed and download a copy of that, and that way you'll have the legal description and the other information that you need to get started with your search. Beyond that, they probably are not going to have it online. Most counties don't. You'll need to actually go down to the county department to do your chain of title, working your way back through time. Now, once you've got the plat map, which is something you should also be able to get through a service like Parcel Quest, or I would give you if you were buying a property from me, you need to be able to figure your way around the plat map. And for that purpose, I was going to show you a few plat maps here and just some of the problems that you might run into. So these are parcels I've dealt with. Here's an example of a problem that I ran into where I bought my property. This was the plat map that came up with it. Incidentally, they're called plat maps. You might think they're called plot maps. I've seen that before, where people think it's a plot of land, so it's a plot map. No, actually, they're called plat maps with an A. Took me a while to figure out where my property was on this, because it didn't match up with anything until I realized, although it's not very clear at all, this arrow is pointing in the northward direction. This map is sideways. This Los Angeles County line here actually runs east and west, not north and south. So the whole map is sideways. And it really doesn't make much of an effort to tell you that when you look at it. So don't always assume that everything is right side up when you're looking at a plat map. There's an example of where it wasn't. Here we've got another plat map. Now this one is sideways. I'm going to turn it around to make it a little easier to look at. Zoom in a little bit. Now, here you go. This area here, that indicates easement. Not just that is where the legal easement through somebody's private property is. That is, in my experience, that always means it's a county road. The county has actually designated that as a road that theoretically the county is supposed to maintain. Whether or not they are is another matter. But that's, you see solid lines. Whenever I see solid lines like that, it means it's not just an area where there's easement running through private land. That means there's actually a county road there. In that particular instance, that's exactly the case. That's property I own right there, and that is county road, which is a really nice feature when you run into that, because it means that they are required to maintain it. And there's no question about whether or not you can get onto your property. Move on to another one here. This is a big chunk of land. I bought that property some time ago and sold it. And now what are these dotted lines here? I never did find out. And I called and I tried to talk to people and ask whoever I could. Never got an answer. And I don't think these are universal. It's not like you can't. There's not like some legend somewhere that you can look up and figure out that there's certainly nothing on the map to tell you what. Here we go. There's the arrow again pointing northward. That's your indicator of which direction, but unless you know to look for it, it doesn't really clarify that. In this instance, that is legal access. There's a road there that's developed, but it's dotted line. It is not county, it's private. And that's private property. So whenever you're going through a road like that, this here is county or state road. But this here is private property. But it is designated as easement. Now my property is right there, so I had a little bit of trouble. How am I going to get to my property? I had to go back to the 1950s to be able to establish that easement, even though there's other places where it was clearly marked on the property. There's an easement. As it turned out, there was easement, legal access on my property, but I just had to do some work to figure out how. Now, that there is nothing. It was something at one time, but no more. These are. But that just takes a little time to research that and figure that out. This is just kind of a close-up of that last one. What's notable here is that this property was a larger 5-acre property that was then subdivided into two 2.56-acre properties. So obviously it was originally slightly more than 5. It was like 5.05. And as it turned out, legal access was available through here. But these people did what's called a lot line adjustment. They owned both properties, and they did a lot line adjustment, which is indicated here by this break in the line there, meaning that they wanted this to be one solid parcel. And the easement that ran through there, they moved over to here. And so, as a consequence, it was on the more current deeds. You're reserving, therefore, an easement for egress and ingress over the north. Well, no, actually, this is not the one I should be pointing to. There was, on a current deed of theirs, this one here is the original one that I had to go back to. As you can see, 1950, I had to go back that far. And that's when I discovered the language. They're showing that actually there was several ways. There was about 3 or 4 different ways that I could get onto my property. And then it was just a matter of figuring out which one's going to actually work. But important thing is there. You may have to go back a ways. I wanted to show you something else about that property before I moved on. This is kind of important. When I sell properties, and when I look up properties, one of the things I look up, and you would probably want to look up, is the GPS coordinates. And you take those GPS coordinates, you can plot it onto Google Earth, or you can go out there with your GPS unit. And if you do that, it tells you that this is where the property is. And that's where I thought my property was originally. It was completely wrong, and that is not unusual, especially when you get into remote areas. The GPS coordinates are usually way off, not uncommonly at all. So this shows where, for example, the northwest corner was. So according to my GPS coordinates, the northwest corner was there. Actually, the northwest corner was there. That's like 150 feet off. That's as much of a discrepancy as I've ever seen. It's usually a matter of a few feet, maybe 10 feet, something like that. This was wildly off. And it ended up causing me some trouble. Eventually, I figured out exactly where my property was. It helped that when I went there, there was markers in place. There was physical features in place that demonstrated where the property was. And so just especially when it comes to remote properties that are far and away, you just can never count on the GPS coordinates being spot on. But when you look on a service like Parcel Quest or Title Pro or any number of different services, they'll show you an overlay like this over the property. You kind of got to be able to figure out what the physical features are in place and where your property is. This one was so wildly off that it was very difficult to figure out. Most of the time you can kind of make an adjustment because you see there's a bend in the road or something like that, and you just know that you got to shift that down, 15 feet or so to the south or something to correct for how off the county GPS coordinates are. At one point I was going to spend the money on a GPS system that was accurate down to inches or millimeters. But then I realized that there's no reason to do that at all because the coordinates are not reliably accurate. So I use a GPS now that's to within 10 feet under most conditions, and it's between that and the plat map and going out and checking out the features in place, you can usually figure out close enough where the property is. Here's another example. This shows this entire area is private property. They put a road in here, and they put the property boundaries right at the midpoint on the road. That's not uncommon. That's very normal in private areas. So anyone who's getting back to their property is going to be traversing all those private properties to get to their property back here, let's say. That's just the way it is, and that's why it's important. For the most part, especially if the road is established, you can see it. There'll be a sign on the road pointing it out, and you know that people are taking it. You don't need to worry too much about looking up the deeds of each one of these properties in between and proving to your satisfaction that they all have that language somewhere 50 years ago, conceding that this is an easement through their property. If it's an established road and there's markers up, you're probably safe. You're probably just fine, assuming that you'll have safe passage. But there should be, and in this particular instance, there was language in the deed specifying that there was an easement. I think this was my property. No, actually, this was my property back here. There was language in the current deed, which was unusual, that said that the 15 feet on the west side of the property were easement for public access. It should be in every deed, and I don't know why, but they just get dropped. Here, this is a large subdivision of a number of properties, kind of set inside of a bunch of public land or a BLM land. And if you go to each of these corners, there's a geologic survey marker, and that's I happen to buy that property there, so it's kind of nice that I had a geologic survey right there on one of the corners of my property, and I could pretty much figure out where the rest of my property was from there. But that was a bit of a trick finding that one, because there was like no physical features to work off of really. So that's what plat maps look like, and that's what the language in the deeds should look like. That's going to vary, of course, wherever you go, and each county is going to be different. Don't expect it to be always exactly like that. Different county might have worked with different cartographers, and they'll have different ways of indicating that there's an area that's where there's legal access across private property. Those maps that I just showed you made it very clear where the legal access was on the private property. Most of the time, it won't say that. It won't say anything at all. In fact, on one of the deeds that I just closed, that large quadrant that I showed you, where there was GPS geologic survey markers on each of the four corners, in that particular instance, because it was a rather recent development, most of the deeds in that area had language still saying that there was easement on the south or the west, or actually on that particular instance, most of them had easement on all four sides. So access shouldn't be a problem for any of those properties, but it's kind of a newer development. And on older developments, it's not going to be as clear as that. But on the plat map, you'll notice there was no indication. There was no sort of dotted lines or anything like that spelling that out. You had to rely not on the plat map, but on the deeds. So each situation is going to be a little bit different. So that's why I'm trying to give you a lot of information to kind of give you more to work with. So let's say you've determined where the legal easement to get on off your property is. You visited the property, you walked in, and you checked out. And I wouldn't proceed without physically examining the property, physically seeing what you're dealing with and what maybe is designated as legal access, where you're hoping there's going to be legal access. Maybe there's not physical access. You definitely want to really know what the property's like. And let's suppose you're having a little trouble dealing with the neighbors. What are your options? Assuming that you can even get them to respond. What are your options, even if you can even get them to respond? Don't be surprised if you send them letters and then you never hear back. They don't want to talk to you. It's as simple as that. They want your problem to go away, so they won't even respond. Don't be surprised. That's just how people can be. In a situation like that, I would send certified letters once I've established that I have legal access on this property and they're not being responsive. I would send them a certified letter that they have to sign for, making the case, demonstrating them from the deeds how you do actually have access, and I would just proceed. And that's what I would do, and see what they're gonna do about it. You have the rights once you've established it, and they're just gonna have to yield on that. Another option, if you're having a little bit of trouble with a neighbor, is to go to court. To go to court and get what's called the declaratory relief. And declaratory relief refers to a judgment of a court which determines the rights of parties without ordering anything be done or awarding damages. By seeking declaratory relief, the party making the request is seeking for an official declaration of the status of a matter in controversy. Optimally, the resolution of the rights of the parties involved will prevent further litigation. If it doesn't go well, a lawsuit may be the only thing that'll get a neighbor to cooperate. One other way to research an easement exists in some. If you look up in some old deeds, you might find some language that says, as found in book 3246, page 445 through 447. Now, if you see that, you can go and look up those books. Those are also going to be at the recorder's office. You may need to ask someone behind the counter, how do I find that? Because it may not be in the regular system that you would, where you're looking up deeds. It probably would be a separate system, probably on microfile or something like that. But you can look up those very old records, and that may have some very helpful information for doing your detective work. So you have the options of establishing through detective work, looking back through the deeds, doing an easement search, and getting yourself certified copies of the documents, the recorded documents that establish you have access. That's the most direct path to getting easement onto your property. After that, like I said, you could buy the easement by just negotiating with the landowner. But there's another way. In California, this is maybe specific to California. Other states may have something similar to this, so you may need to do some homework on your own. But there's other ways in which easement can be granted. One is easement by express grant, which is what we're talking about when we're discussing the easements being in the legal, in the description of a deed. But there's also easement by prescription, which means that easement may be established upon showing a court by the claimant, by the person who's trying to establish the easement, that he has used the easement openly, notoriously, and continuously for a period of 5 years. You may have heard about something like this. The claimant's use of easement must be hostile and adverse. These are technical terms I'll unpack in just a minute. If the owner has given the claimant permission to use the land, then the easement by prescription will not be found. So essentially, if you have a situation where you have a path to get onto your property by traversing a neighbor's property, and you do so openly and notoriously, which means that the occupation of real property in a way in which anyone can observe as if the person's the owner, and continuously for a period of 5 years without the person whose property you're traversing, they must be the situation that they're aware that you're doing it and they don't do anything to stop it. If all those conditions are met, that you're traversing this person's property openly in plain sight, they know about it, they do nothing about it, and this goes on for 5 years, easement is legally granted at that point by easement by prescription. Kind of a peculiar set of laws, but not too many circumstances where I can imagine this really coming into play, but it could. There's also easement by implication, and that requires a legal action. Easement by implication occurs where there is a necessity. And this is an important point, where there's a necessity to use the easement, and also that the dominant and servient, the servient being the one that's being granted easement by the dominant one, were under common ownership when the need for the easement became necessary. This is California law. Easement by implication meaning that when the need for the easement arose, both properties were owned by the same person. You can have legal easement by implication can be established, and that would need to be done by a court. And then finally, there's easement by necessity. This is again California, as I was mentioning. Pretty much what it sounds like. A court can grant easement because it's simply necessary. I go to court and I argue to the judge, I've got no other way of getting onto my property, and the court will grant that easement by necessity, because in California, at least, you cannot be denied access onto your property. And I don't know how many other states. I shouldn't make any statement about other states. I know I was in conversation recently with somebody in Colorado, and they said that's simply not the case in Colorado. In Colorado, you can be genuinely landlocked. Bummer. Bottom line is, at least in California, don't give up hope. There are ways to get on and off your property. Legal ingress and egress in a state like California certainly does exist. It just may be quite a bit of a bother to get it established. If you're buying from Clear Skies Properties, I don't get into trouble like that if I can at all avoid it. And if I do encounter problems like I have, where a property where I didn't realize, because I didn't know exactly where the property was, I was mistaken. And I ended up having some easement difficulties. It looked on the survey map, it looked from the Google Earth that I had a clear road onto my property. When I got there, I realized that it was not a road at all. It just looked like it from the air. And I got into trouble with that, but I managed to sell it to a neighbor nearby. That's it worked out fine for me. But but you don't want to get into trouble like that if at all you can. So this is why you have to do your due diligence. You have to do your homework ahead of time when you're buying properties. And access, you know, it's almost as important as location, location, location. You don't want to get into a situation where it's going to be expensive and time consuming and a bother and a battle to get that established. So you want to establish that going in. So that's it. There's a lot more to be said on the subject, obviously, but that's, I think, quite long enough for this tutorial, and hopefully that was helpful. If you have any questions, you can give me a call, or better, speak to a lawyer, because I'm clearly not a lawyer. That's it. Thank you for your time. Talk to you later. Bye-bye.